Welcome back everyone. Today I'm going to summarize the third essay in the book on citizenship, which has been written by four eminent personalities. First essay is by historian Romila Thapar. The second essay is by journalist N. Ram. The third essay, which I'm going to review in this video, review less but summarize more in this video, is written by a lawyer, Gautam Bhatia. And the fourth essay is written by Justice Gautam Patel, who is presently a judge at the Bombay High Court, whose essay will also be reviewed by me in the next video. So the title of the essay that has been written by lawyer Gautam Bhatia is Citizenship and the Constitution. In his essay, lawyer Gautam Bhatia talks about how India's constitution, when it was being framed, was framed under extraordinarily challenging circumstances, because not only did we gain independence, but there was also partition that was going on. And despite all of this that was happening, we added very lofty principles in our constitution, and we try to imbibe all of these principles in our preamble and in our fundamentalized chapter. Now he talks about the impact of partition, which was most visible in one chapter of the Constitution of India, that was the second chapter, which was citizenship. He raises the most fundamental question, that is, what does the Constitution say about the citizenship? He says the Constitution says nothing except for the fact that there is a second chapter, and that second chapter provides for various dates. And if you have arrived in India till those dates, after partition, after independence, then you will be accepted as a citizen of India, or there is another way, that is to be a naturalized citizen. Now, all of the controversy that raged after CAA 2019 was that there were some classes of people who belonged to three countries: Pakistan, Bangladesh, and Afghanistan, and belong to six religions: Hindu, Jain, Buddhist, Sikh, Parsi, and Christians. And they had come to India before 31st December 2014, would be granted immunity from prosecution as illegal migrants, and a fast track to citizenship. Now he argues that the only thing that the Constitution says about citizenship and granting of citizenship is that the Parliament, under Article 11 in the second chapter, would be empowered to make any law regarding the grant and procedure of citizenship. But then he argues that the Constitution, by giving powers to the Parliament, has not excluded Chapter 2 from the ambit of Chapter 3, which is fundamental rights chapter, which is that if you are making any law under Article 11, you have to make that law in consonance with Chapter 3 of the Indian Constitution, which cannot be denied. And that is his main argument throughout the whole essay, that any law made by Parliament has to withstand the test which has been given under Chapter 3, that is fundamental rights. So he says that any law which has been made cannot violate any fundamental right. Now there is another argument. That argument is that any person who is coming from these countries and is not a citizen, is an immigrant in India, would all the fundamental rights be available to that person? But then he argues that there are various fundamental rights, which is 14 and 21, which come into effect here absolutely. That is, 14, there has to be equality of law, and 21, which says right to life and personal liberty. He argues that the main defense that is taken by the proponents of CAA is that there are two forms that they take. One is very strong, and one is a softer form of stand that they take. The strong form is that Article 11 exempts citizenship law from any constitutional objection, and that is including from fundamental rights challenge, which I have just explained. It says that Article 11 uses words like any provision and all other matters. He says that I'm not going to engage with the argument any further, because I believe that Chapter 2 is not an exception to Chapter 3, which is fundamental rights chapter. So any provision made under 11 has to be in consonance with Chapter 3. Now he says that there is a weaker form of argument which the proponents of CAA take. What is that weaker form of argument? It is that the Constitution never intended to bind Parliament to a particular principle or set of principles on citizenship, and subject to any constraints of fundamental rights, which are already mostly limited to citizens. Then he argues that the discrimination with religious minorities provide the rational basis on which this, weaker form of argument which is being made, rational basis for Parliament to pick them out for special treatment. And then, then that would fall under reasonable classification also if it is to be tested in the Supreme Court of India. And he says that I'm not going to examine the constitutionality of CAA, and that is what Justice Patel will also say in the next video. But he says that the question is that what does the Indian Constitution say about the citizenship? He says that the idea of Indian citizenship is interwoven with Indian constitutional identity as a whole, that is secularism, egalitarianism and non-discrimination. And then he goes on to say that the careful reading of the Constitutional Assembly debates reveal that while the Parliament was free to legislate on citizenship, it was always to be bound by the defining features of the Indian polity. Parliament could not and was not intended to ever create conditions for entry into the polity through constitutional laws that were democratically that were fundamentally at odds with its secular and civil nationalist identity. Now, when he says about secularism, now obviously he is talking about how there are certain religions which are being discriminated against and they are not being allowed into India. Then he says that under Article 11 and the Constitution, religion cannot become the basis for citizenship in India. Then he talks about Constitutional Assembly debates in very great detail. He talks about phase 1 when there was this discussion in the Constitutional Assembly as to how to grant citizenship. So there were 3 basic ideas. First was universal, that is anybody can come in and they will be given citizenship. And then there was this racial idea that was being floated, which was that if there is a person who is able to prove that, for example, say Aryans, that they belong to the race which has been inhabiting this place for a long time, then they would be given citizenship. For example, say, or on sectarian basis, that you are a Hindu, so because Hindus do not have any other country in the world, any Hindu can come in and they will get a citizenship in India. Then there was this phase 2, which was that partition, and that was that when all of this was going on, another event happened, that was partition, and that is why so many dates have to be added. And the violence of partition remained fresh in memory when all of these laws on citizenship were being made. It was inevitable that when the Assembly considered the draft constitution in the months of November and December 1948, and then again in August and September 1949, partition would cast a long shadow over its deliberations, and especially in its deliberation on what it meant to be an Indian. Original clause now needed to be complemented by a host of detailed provisions dealing with partition. Dr. B.R. Ambedkar collated them and came up with a fresh draft of Constitution clause. And then he talks about a member of the Constitutional Assembly, Mr. Musafir, who coined this idea that the citizenship should be based on religion, and his idea was further taken further by Mr. Deshmukh, who was also a member of the Constitutional Assembly. He took the idea further and said that if Pakistan can allow citizenship on the basis of mere religion, then why not India? But then the Constitutional Assembly accepted Dr. Ambedkar's draft, that was that the citizenship would not depend on any religion, and Mr. Deshmukh's resolution was defeated. And then he talks about the last and the final phase, that is the third phase, that is finalizing the constitution, the warp and the weft. In this he talks about that in the Constitutional Assembly there was this general consensus that we have arrived at a decision that the citizenship of India is not going to be based on is not either going to be racial, or it's not going to be based on a race or on the sectarian basis. It is going to be based through cutoffs. Either you are living in India or you have come back to India, you have demigrated from the partition territory till a certain date. And that is when he says in the end that, and through a reading of these speeches, I suggest that we can glean a fundamental insight. The citizenship provisions were never intended to be read in isolation. Rather, they formed one strand in a web of harmonious and mutually reinforcing principles which is woven together made by the constitution. And this, I suggest, is the fundamental flaw of the article 11 defense, that is that it has to be seen in isolation, and the part 3 of the constitution does not apply here. Then he says that it attempts to read the whole of Article 11 in glorious isolation, ignoring the fact that citizenship, like the fundamental rights, the directive principles, the federal structure, and the rest of the constitution were part of a coherent web of principle, not single strands floating in the air. So, in this way, he makes a very compelling argument that Article 11 does not stand in isolation. Whenever it is to be tested, it has to be tested on the basis of violation of fundamental rights. Then, in the end, he says that the constitutional commitment to secularism and non-discrimination acts as an implied limitation on the Parliament's power to determine citizenship under Article 11 of the Constitution. Citizenship as a condition of entry into the political community cannot be such as to defeat the founding identity of that polity and an identity enshrined in the Constitution. And that identity is non-discrimination, sectarian, non-sectarianism and secularism. So thank you very much for watching. I'll be back next Sunday with the fourth essay, which has been written by Justice Gautam Patel. It is a very, very interesting essay, and it talks about various judgments from throughout the world. Till then, take care, stay safe, and don't forget to subscribe to my channel. Thank you.